We're ready, counsel.
Good morning, Your Honors. May it please the court, Ben Cuney representing James Ware, whose murder conviction and life sentence are pending in this appeal. I respectfully reserve 4 minutes for rebuttal time.
All right.
This appeal challenges a number of issues. First, we challenge the stand your ground ruling for a number of reasons. Next, we object to the trial judge's failure to give a necessary special jury instruction dealing with the premeditation issue. Third, the closing argument, the rebuttal closing argument of the prosecution unfairly intruded into a burden-shifting argument that was promptly objected to and preserved. And finally, the evidence of first-degree murder is not supportive of that degree of conviction, and at a minimum, this court should reduce that offense of conviction to second-degree murder, if not outright discharge Mr. Ware. The facts are known to the court, and we start with the stand your ground immunity ruling. There are 3 deficiencies to the stand.
Mr. Cuney, I just want to interrupt you for a second. I'm sorry. You have raised a lot of issues, and are you planning to address them in order, or are you? I would really like you to start with what you think your strongest issue is. And if
Yes,
it's to
Your
stand
Honor.
your ground, fine. But if that would be my preference, if you could do it.
Thank you, Your Honor. The first issue to address is the stand your ground ruling, and it comes into 3 deficiencies. First, the order itself is woefully deficient in that it contains no factual findings or conclusions. It merely reports the prosecution.
Yes. And, let me stop you there, because, that's a little bit of a conundrum. And it's not really the first time, obviously, that we've run across a situation where you have something we're reviewing that has the mixed standard of, deference to the findings of fact of the trial. Most often it comes up, for instance, in suppression motions, review from suppression motions, and then a de novo review on the question of law. And I didn't see any really clear answers in the cases that either of you cited on really, as the appellate court, what are we supposed to do when we have a record where the court did not make fact findings, either orally or in writing, yet part of our review is whether their determination is supported by competent substantial evidence, or in this case, clear and convincing. Well, competent substantial that there's clear and convincing. So I would really, I would love a silver bullet direction on, well, what are we supposed to do when that happens? I've seen cases all over the place. And that's why, I would really like to hear something about that from both of you.
This is what the case law suggests, Your Honor. And there is no clear definition of how the courts are supposed to do this. But first, the trial courts have been told numerous times, factual findings are necessary. In this particular case, they are more than necessary because of the nature of the stand your ground evidence. Mr. Ware's statement to the police, coupled with evidence from the prosecution, basically the detective's evidence and the medical examiner's evidence. And we raise a substantial issue on the validity of their opinions. Without any factual findings, this court is left with either to decide in terms of the procedure, is this matter appropriate for de novo review completely, with this court taking on the responsibility of the trial judge to do what the trial judge is supposed to do, which is not normally the preferred methodology for this court. The court should, in fact, send it back down for required fact findings. But if this court decides we will do what the trial judge refused to do, then all of the arguments that go to the evidentiary issues need to be grappled with by this court. I can address them briefly, but that's not normally the review process this court uses. But pure and simple, Mr. Ware gave a statement. The statement was a fairly long statement, 30 to 45 minutes, that consisted of him making introductory remarks and then answering the detective's questions. Mr. Ware was consistent throughout his statement, did not offer a different version of the statement at trial. He did not testify at trial. This is only the stand your ground hearing. And two items were used by the prosecution to undercut his statement. One is, and both of them are pure rank opinion, not entitled to any evidentiary value at a trial court level or at a jury level. And those two deal with the issue raised by the medical examiner. A knife could get slippery, quote, I have been told, end quote. Not her medical examiner, not Dr. Deaver's medical examiner history, just anecdotal. And similarly, the Detective Price, says it's quite common that a knife gets slippery, comparing Mr. Ward's case to other commonly understood cases, which don't come within lay opinion because they're not common matters. They may be common to law enforcement investigators.
I don't know. Anybody who's ever had a cut knows blood is slippery. I'm not all that persuaded that testimony is beyond the realm of common experience, but go ahead.
But what
In
those
addition,
two,
Mr. Cuny, their supposed hearsay or expert testimony, however, is consistent with Mr. Ware's statement that after multiple stabbings of this woman, he stops, he wraps the knife around in a pillowcase or a towel, and then continues the stabbing. So there arguably is some consistency between all that testimony, is there not?
there is no doubt, Judge LaRose. The point, however, that these two speculative opinions had and used by the prosecution, frankly, very successfully, was to say Mr. Ware's wound in the webbing between his thumb and forefinger was not caused by a defensive blow, as he said during his consistent statement, where the decedent attacked him, but instead they concluded this was because of the knife slippage. Somehow slipping the knife caused him to cut his own webbing, a type of defensive injury that is consistent with Mr. Ward defending himself. And that
Just to
attempted
stop you real quick, just to make sure, did he affirmatively say during his statement, did Mr. Ware say, explain that his injury was the cause, or are you drawing an inference? Are you connecting a dot between his testimony that she did attempt to stab him and he was defending himself?
Judge Atkinson, the record is clear and precise on that very point. Mr. Ware testified that she attacked him with a knife and cut his hand. I believe the record references are in the 120 to 125 and 127 to 130 area. And the Attorney General, the state, admits as much on page 26 of its brief, but instead says that just makes no sense that she was attacking him with a knife, even though there is absolutely no evidence to suggest it made no sense. That was 100% consistent with the testimony, not the testimony, the statement he gave, and consistent with the nature of this offense, a case that involved a homicide, no ifs, ands, or buts. The perpetrator of the killing is plainly Mr. Ware. The only question for stand your ground purposes, was he reasonably acting in self-defense, and did he reasonably believe force was necessary to stop the attack? And we have
I'm sorry, finish your point.
We have corroborative evidence of the decedent's violence, her regular use of weapons, knives, her imposing nature and dominant physical ability over Mr. Ware, and no history of violence by Mr. Ware in the relationship with the decedent.
Well, let me stop you, because assume all of that is true and that he did get the cut defensively. But at some point, he got the knife away from her. And that's when he started stabbing her. So repeatedly. And, at some point, doesn't that negate self-defense? Is that how, what does that do to your argument that he had reasonable fear for his life when he has gotten the knife and has started stabbing her and she's incapacitated, but he continues to stab her to death?
And blunt force trauma with another object besides a knife.
Yes, Your Honor. First, on the blunt force trauma, he stated.
Well, don't let me derail your answer to Judge Kelly. She asked you first.
I understand. I'm wrapping
It's okay.
that. Blunt force trauma. He admitted he hit her with a ceramic planter, and the battle continued, meaning her attack on him continued. So there are two reasons why, Judge Kelly, the comment about the continued stabbing is neither decisive nor an answer to the stand your ground. One, without any factual determination, we have no record for the judge saying his initial act was self-defense, but the self-defense was no longer reasonable, the use of force, because of the circumstances. And second, we have undisputed evidence that Mr. Ware was in a frenzy, his statement and the factual circumstances, and there was no separate determination. It was a frenzied stabbing. Not right, not acceptable, but under the circumstances.
But that could still negate then the frenzy. I mean, that could negate the reasonableness element of reasonable fear element of self-defense, couldn't it? I mean, wouldn't that just go to the degree of the homicide?
Your Honor, it could, only if there's a factual determination that Mr. Ware's frenzy changed his reasonable belief. It's his reasonable belief.
That's not an objective test?
Isn't that an objective standard? Yeah.
No,
I think
no,
is that
Your
what you
Honor.
asked Judge Atkinson? I want to know the same thing.
No, Your Honors, it's a two-part test. Do the facts support his reasonable belief? One, what is his belief? Subjective.
So it's his
and
individual.
Second, is that reasonable belief objectively reasonable? So somebody saying,
Okay.
An alien zapped me and that got me concerned, and therefore I reacted. That person may reasonably believe, but that may not be objectively reasonable. It may change, as Your Honor said, the degree of offense. The person is not acting with premeditation, but it may not be objectively reasonable. But we have neither determination here on this record.
But
And
Mr.
because
Mr.
there are
Cuny, Mr.
Yes,
Cuny,
Judge.
your client's statement, however, suggests that there's a break into frenzy. After multiple stabbings, he stops, he wraps the knife in a towel or a pillowcase, and then continues with the attack. And it appears that when he does resume it, the victim is incapacitated and no longer poses a danger to him.
Two comments, Your Honor. First, to conclude without any factual determination by the circuit judge that there was a break is not consistent with this record. All the record reflects from his statement is that he wrapped his hand or the knife with a pillow or some cloth. Not that the stabbing stopped. Obviously, momentarily it did, but no evidence. Oh, I stopped, I went into the bathroom, I grabbed a pillow or a towel,
But there
I came back.
was a colloquy between the detective and Mr. Ware where the detective said, well, you know, she wasn't putting up another fight anymore, and he said, yeah, you're right. Now I'm paraphrasing because I can't find it the exact page, but are you aware of that colloquy where?
Absolutely, Your Honor. And the importance of that colloquy is not that it did not happen, it plainly did. That colloquy does not get close to answering the question, what were you doing and thinking at the time? Obviously, in retrospect, he says to the officer, I loved her. I loved her. I don't know what happened. My mind was in a frenzy. And remember, he was being treated, and the evidence is clear on this, for mental health issues with the Veterans Affairs. And that's really what begat this entire struggle. The girlfriend being upset substantially that he was no longer able to financially contribute, and it led to a horrible domestic situation, something they had never had before.
Mr. Cooney, I just wanted to let you know, I'm sorry to interrupt. I wanted to let you know, though, you've got 4 minutes left. You can use it however you wish, sir.
Let me just wrap up and remind the court that in this particular case, the special jury instruction was necessary because the state used post-offense conduct, leaving the scene and eliminating some of his clothing, although he admitted to this, to establish.
You're saying some post conduct, a post crime conduct can never be relevant to the question of premeditation?
Your Honor, the law says that post activity evidence is relevant to the issue of consciousness of guilt, not relevant to the issue of premeditation.
Now, there are cases that say it cannot ever be relevant to premeditation.
I don't think there is a case that says cannot ever be relevant. The case law says it's relevant to consciousness of guilt, and the Balzort case by this court and the Norton case by the Florida Supreme Court cited in the brief make clear that post-conduct events do not establish premeditation. And that law is more than clear. It's nearly black letter law. This instruction was necessary and was not filled by the other instructions. And finally, I would ask the court to look at the rebuttal closing argument that shifted the burden of proof. The prosecutor said, in a case where the defense offered no evidence, quote, unless they are asking you to not believe a portion of the statement, end quote, Mr. Ware has admitted to all the elements of the offense. It was not invited, and that was exactly the point. You need to hear from Mr. Ware.
Well, wasn't it? I mean, isn't there another way of looking at that, which is the state was merely referring to its own evidence, which included the statements of Mr. Ware?
It cannot be.
They're not implying that Mr. Ware needs to say more. They're just saying he already said something, and we are adducing that as evidence for our case.
The articulation, the carefully prepared articulation by the prosecutor was clear. Unless they are asking you to not believe a portion of the statement. The defense position had been, Mr. Ware told you what had happened, and you've got to look at all the evidence. This was precisely an effort to say, you didn't hear anything different from him, and he's the only one who can tell you something different. That is a fundamental violation preserved. For all these reasons, we ask the court to reverse and remand for a new stand your ground hearing, or to reverse for a new trial, or reduce the offense of conviction to murder in the second degree. Thank you, Your Honors.
Thank you. We're ready when you are, counsel.
May it please the court. My name is Lindsay Sims Bone and Steel of the Office of the Attorney General, and I represent the appellee in this matter, the state of Florida. To begin with appellant's first issue, the stand your ground hearing, and to Your Honor, Judge Kelly's concern about that there really aren't clear cases on either side. We just submit that there's no requirement either in the case law or the Florida statutes to require detailed written findings in the court's order. That these orders are like decisions that are made on a motion for judgment of acquittal or a motion to suppress, that where there's competent and substantial evidence in the record to support the court's finding, that the court's decision should stand. And here we have an order in which the court only specified that the state presented clear and convincing evidence to establish that the defendant wasn't entitled to the statutory immunity. There was clear and competent and substantial evidence to support that decision by the court based upon the evidence that was presented at this very detailed stand your ground hearing. In the hearing was appellant's statement. They tried to play the video, and so that didn't work for some reason, and there was instead a decision to rely upon the transcript. And the transcript is a little bit deficient, as one of you pointed out, in how his hand injury is purported by him to have occurred. He says blocking, and we can't see on the face of the cold record what he's trying to describe to the officers in that interview.
Well, doesn't that go to support Mr. Cuney's point that our appellate review would be much more enhanced if we had some detailed findings by the trial court that sorted out any conflicting testimony or evidence?
It would be enhanced, but it doesn't mean that this court can't affirm this order based on the evidence at this hearing. We do have photographs at 152, I think, of the record in this case of that hand injury, as well as autopsy photographs and extensive testimony from the medical examiner in this case to the grave injuries suffered by the victim. First, there is
don't we have to focus in the first instance on the fact that he is injured, arguably by the victim, and it is in response to that that he uses force in defense of what had already, after he's already suffered a wound from a knife?
Yes, Your Honor, that was some of the evidence, but that evidence wasn't undisputed by this record. And
that goes to the point of having factual findings.
Yes, Your Honor. It would be valuable, but in this,
I mean, it's not our role to make those findings.
Correct. But where there's competent and substantial evidence to support the lower court's finding, the lower court's decision can be affirmed.
In other words, we would have to assume the court rejected his testimony about it being, acting in that he was acting in defense initially. We would just make the assumption that the trial court rejected that. Is that how this would work?
Well, you could affirm that there was competent and substantial evidence to support the fact that the state presented clear and convincing evidence that he wasn't entitled to statutory immunity. If there had been a reasonable belief that his use of force was necessary to prevent the victim's unlawful action, that certainly had dissipated by the time that he hit her on the head and took with the statuette, which according to the medical examiner, it happened several times. by the time he had taken the knife away, by the time he had stabbed her, and without going into a lot of detail. This is a case in which the medical examiner testified that the victim had over 100 stabbed, incised, and blunt impact wounds. There were wounds all over her body.
No, I understand that. I just, again, you know what, and it's, you know, I've run up against this repeatedly over the last 20 years, where we're in a situation like this, where there's no factual findings, but yet part of our review is to look at factual findings that don't exist. And it's all, you know, I have found that to, you know, put us, sometimes it's, I feel like the case law is very ad hoc. I feel like our approach is ad hoc. Apparently you both said that you don't see any really clear answer in the case law. So it makes me uncomfortable to feel like I'm sitting in the trial court's place trying to make a determination in the first instance.
Certainly, Your Honor. And I can understand that, particularly in cases, when we look at cases like Garcia and Bowe. And Garcia, where we have multiple people with hand-to-hand combat. And it's very hard to know what was at work in the situation, you know, what beliefs, the reasonable belief of the defendant in that case. Or in Bowie, where there's a guy behind a car with a gun, and we don't know whether or not that's, whether it's reasonable to think that the danger has dissipated. But here, we know that the danger is dissipated, because in his statement to Officer Price and Chalmik, defendant explains, yes, at the time that she was pleading for her life, and I was wrapping the knife handle, she was helpless. And the detective—
Is that necessarily inconsistent with Mr. Cuney's point that his client was in a frenzy, and perhaps rightly or wrongly, I'm sort of equating that frenzy with heat of passion?
I don't think that, Your Honor, that this is a case of heat of passion, or that he was overtaken by frenzy, because he's able to explain to the officers quite clearly. What the officer asks, well, why did you keep going? And he says, well, she gets like that, with the profanity and the loud talking. And the detective said, had this been building up over a while then? And he says, yes, it had. And they have a conversation, and he says, you can't communicate with her.
His post crime statements to the officer are not particularly relevant, are they, as to what his state of mind was at the time of the criminal act?
It's relevant, Your Honor, when he's speaking to what was going through his mind at the time of the criminal act. He is certainly explaining to officers why he murdered the victim. And this is a case as well where there was really no adequate provocation. Certainly if somebody came at you with a knife, you would become angry, but would this outcome be the result? The over 100 stabbed, incised, and blunt impact wounds is excessive by anyone's standard. And to say that the victim was violent neglects the fact that there was no such evidence at the hearing for Stand Your Ground. The detective was asked about his investigation.
Let me clarify that. I thought that there was some proffered evidence on that, but that the trial court never made a ruling. Am I confusing that with something else?
Well, there were two motions that were heard at the hearing. One was the Stand Your Ground, and one was the reputation evidence. They wanted to have a motion in limine to allow reputation in the community for violence based upon some 20-year-old police report. In the section of the hearing that was about the stand your ground, the officer said, well, he wouldn't have looked at that because it wasn't relevant to his investigation. And then afterward, the defense attorney talked about what they had sought to put forth at the trial. But that's not evidence.
So there was no proffer of any evidence about her using a knife in the past. I thought I read something about that.
There was discussion about a police report or 2 police reports, perhaps, that happened way back in 1995.
Mm-hmm.
But we also have from the detective that the victim was intimidated. And we also have the factual situation that here is a case where we have a woman who's had 2 knee construction surgeries. She's on chemotherapy. She's fighting breast cancer. She's intimidated, and she's trying to exclude this person from her home. She's trying to get him to move out. And, in spite of all that, and this is why in my brief I say, there's things that don't make sense about the way that this argument started. She's trying to get him to go into another room. And she's not saying, oh, you have to get out right now. She's only saying, well, you'll have to get out on Monday. So she's saying, take your things and put them in the other room. This is not a basis on which a person would attack someone with a knife. It's contrary to reason. There was also testimony at the hearing in his statement that there was a financial motive. She was excluding him because of finances. And then in part of this testimony, he took her, after the crime, he locks her in the room, he takes her car, he takes her purse, and from that, he cashes out all her EBT. He literally takes her last dollar, which would be consistent with, if not premeditation, certainly a desire to have everything that she had. If there's no further questions.
What's a good case you could refer us to? Let's assume that his post-crime activity is consciousness of guilt or something, but what is it that supports the proposition that it goes to premeditation?
In my brief, I cite to, I hope I have it here. I cite to default that evidence from which premeditation may be inferred includes, among other things, the accused actions before and after the homicide. In the reply brief, appellant cites to a Utah case, State v. James. And in State v. James, it's a case in which a child has been murdered, and the Supreme Court of Utah actually affirms the evidence that comes into the trial about his efforts to conceal the crime. And it did go to premeditation because there was a connection with his visit to the scene the day before of the offense. And so there's a connection between hiding things and having visited the place where he hid things. Similarly here, we have flight, we have concealment, we have consciousness of guilt, and we also have the financial motive.
Did the state argue in closing arguments? I think it was in rebuttal when this came up. Did the state actually argue that it was evidence of premeditation, or did the state argue that it was evidence of a guilty conscience?
The flight.
In other words, the objection, or or the issue on appeal is whether he should have been afforded an instruction on that the evidence is not evidence of premeditation. Evidence of his post homicide actions should not be adduced or cannot be evidence of premeditation. But what was the state's argument? What it was in rebuttal, right? And what was the state actually? Did the state actually connect the evidence to premeditation, or just a consciousness of guilt?
Your Honor, my reading of the state's closing is that we never connected that to consciousness of guilt. The state's argument in closing.
Well, I'm saying the distinction between premeditation and just a guilty conscience. In other words, did the state? That's the distinction I'm drawing.
The state's argument in closing, in this case, was that the premeditation was shown by appellant when he wrapped the knife, and she's pleading for her life and says, I love you. There's no one else. I have a son. I have a daughter. And he says, I'm tired of you. You got to die. And then he goes into the kill and finishes her off. That's the state's argument in closing about premeditation.
Okay, I want to just clarify, because a couple times you said financial motivation, which I don't remember seeing before. I might have missed it. That was part of the state's argument, that this was a financially motivated offense.
The state's argument in the stand your ground.
No, I want to talk about at trial right now.
The state's argument at trial wasn't that it was a financially motivated offense. It was that, but the state's position was never that it was really a self-defense case, that there was no evidence that she came at him with a knife, but rather that there was a homicide. But certainly the evidence was presented that he concealed the crime and took the car and the purse.
But the tension that arose between them, as I understand it, he was waiting to get VA benefits. That was denied. And then I guess the victim is somewhat upset that he is not in a position to contribute to the expense of the household. And, you know, it just heightens whatever tension existed between them, right?
That's correct, Your Honor. And perhaps that is where, in my brief, I saw financial motive, right? That he's unable to contribute. It's because of money that this argument is arising, and he is also taking her property following the crime, as well as the homicide.
I read it a little bit differently. It is equally plausible that because of her concern that he did not get his benefits, that is what prompted her to sort of go after him, because he's not contributing and she wants him out of the house.
I think it's undisputed on this evidence that she wanted him out of the house, certainly. But on Monday, and she had left, she had told him to leave, she'd left, she'd come back. There was no immediacy to an argument specific to getting him out, as if she were trying to drive him out of the house right at that time.
You're just about at 20 minutes, if you'd like to wrap up.
If I may, Your Honor, we would submit that as to issue 3, the trial court properly denied the special jury instruction because the standard instruction was read, it was presumed correct, and it did specify that the premeditated intent to kill must be formed before the killing. And also, as to the closing argument, that this was a statement as to the state's evidence our evidence, which was his confession to the offense, and not a burden shifting argument as contemplated and discussed in Warmington 2. Those were all cases about this state making a comment on defense evidence. Here, the state is saying, our evidence showed that. And remember, the state's argument in closing is that premeditation was shown when he wrapped the knife and he telegraphed to her with his express statement, you got to die. That's evidence of premeditation under Florida law.
Thank you.
Thank you, Your Honor. If there's no further questions, we would ask that this court affirm the conviction and sentence in this case.
Thank you. Mr. Cuny, you've got 2 minutes.
Thank you, Your Honors. The first point is to ask the court, just when you want to understand the court's requirement for factual findings in a stand your ground, just reread the court's decision in Bowie versus State, which was decided just last year. And in that case, to remind you, the trial judge made extensive findings and found stand your ground did not apply. This court, based on those factual findings, deference, reversed and granted a writ of prohibition on stand your ground because the record was fully developed and this court could apply those facts to the law. We don't even get close here. Second, the court, Judge Kelly, asked a question about evidence in the record of a proffer of the decedent's background. Footnote 4 of the initial brief makes clear, and it cites the motion in limine, the defense asked the judge to consider the prior activity, not remote, prior activity of violence known by Mr. Ware in evaluating this. The judge says, well, I'll consider it if I find it to be relevant. Never again do we have a finding or a conclusion on that. The defense offered it, it's in the record, and we have no comment whatsoever from the trial judge as to what role that formed in his reasonable belief or any of the evidence.
The state filed a motion in limine on that?
No, Your Honor,
right?
the defense filed a motion in limine to accept the
Okay.
evidence
All right.
of
Okay.
I guess it should have been a motion to consider evidence, but it's styled as a motion in limine by the defense.
Okay.
And third and finally, Your Honors, Judge Atkinson asked a question about whether the post conduct was connected to the premeditation or consciousness of guilt. One very clear statement from the prosecutor in opening, closing, and rebuttal. This is proof of premeditation. That's what the prosecution argued, and that's exactly why this evidence—
He argued that the actions taken by Mr. Ware after the death were evidence of premeditation?
Yes, Your Honor, and
Where
I
is
would
that?
point out pages 892 to 900 of the record reflects the prosecution arguing that the evidence is totally consistent with premeditation. There is not a single suggestion of consciousness of guilt. Frankly,
what we're talking about is, I didn't mean in general, I meant the evidence that for which you are arguing, the evidence that you are arguing supported a instruction in order to prevent the jury from in their minds considering it evidence of premeditation. Did the state ever argue that that evidence was evidence of premeditation?
Not using that truncated clause, Your Honor. All the prosecution's argument was this evidence, and it includes the, let's call it the post-event escape evidence, the statements he made during the custodial statement. This evidence proves the elements of premeditation. And the jury was left to consider, well, this is evidence. It proves the proof of premeditation.
Mr. Cuny, I'm
Therefore, we
sorry
can
to cut
consider
you
it.
off. I gave you a little extra so you could answer Judge Atkinson's question, but your time is up, sir.
We can review the transcript. Thank you, Mr. Kinney.
Appreciative. We ask the court for the relief requested in the brief. Thank you, Your Honors.
Thank you both. Okay, our next case is Peterson